Norman Clark of Clark and Company Benefits, and I want to welcome each of you to the call. We're glad you've joined us today to hear about the Families First Coronavirus Response Act. I want to thank our presenter, Jack Cohoon from Burnette Shutt McDaniel, for taking his valuable time to go over this act that starts today. Due to the amount of people on the webinar, if you have a question during the webinar, we request that you type it into the question box, and Sully Da Silva in our office will be monitoring questions. And after Jack's presentation, we will do Q&A from the questions and any others that come in. It is an understatement to say that we're in uncharted waters in our country right now. Laws have been passed at lightning speed. We're interpreting them on the fly and making decisions that not only impact our businesses, but really have an impact on the day-to-day lives of our employees and their jobs, well-being, health care, mental health, and so many things that affect their lives and livelihood. This is a difficult time for all of us, and we're trying to get everyone as much information and guidance as possible through the web, emails, and phone calls. We are working on a CARES Act webinar as we speak, and we'll get it together as soon as possible and get it out to each of you for hopefully next week. We're pushing info out daily to our Clark & Company employer and employee web pages that we have built for COVID-19 that are on the screen, and they're available and for your pleasure to go out and pull any information as it comes available. Yesterday, we posted a COVID-19 emergency loans and small business guide prepared by the U.S. Chamber of Commerce on the CARES Act, so you may want to go read that also. We have included the web addresses to both the employer page and the employee page that we've prepared for COVID-19 resources, as well as the Burnette Shutt blog on the screen for their updates also. And I can say with everything the federal government has passed, they've been pro-business and are trying to make it where small business can stay alive and be ready when things return to whatever normal is. I want to again thank Jack for his time, because most of us are subject to the FFCRA. And my message is to everyone, our employees and everybody else, that we're going to get through this. And sometimes we lose sight of all that with all the bad news that we're bombarded with daily. All of our staff is here remotely to help anyone navigate their challenges as it relates to the benefits and any of the new laws that are being passed. I want to thank everyone for their time today. And if anyone wants to view or share this webinar, we are recording it, and we will post it to all of our websites and send a link to you all via email. I want to turn it over to our presenter, Jack Cohoon. Jack serves as special counsel to Burnette Shutt McDaniel here in Columbia, South Carolina. He has nearly 14 years experience helping clients find solutions to employment issues and other legal problems. Jack holds a law degree from the University of South Carolina School of Law and a Bachelor of Arts degree in History and Political Science for the University of Georgia. Jack, we appreciate your time in preparation for today's webinar, and I'm going to turn the presentation over to you. And remember, type in your questions. Sully will be monitoring them, and we'll come back for Q&A at the end of the presentation. I'm going to switch it over to you, Jack. Thanks for your time.
Thank you, Norman. I appreciate you letting me share this information. As Norman said, I'm special counsel at Burnette Shutt McDaniel. We are a modern and progressive law firm. We represent clients in many different legal areas. We have 2 certified specialists in employment law amongst our attorneys, and that's though we handle many different types of cases, employment law is an area of special interest in our firm. So today we're going to talk about legal provisions of the Family First Coronavirus Response Act. This is an early phase in our federal government's response to the coronavirus, and it goes into effect today, as Norman mentioned. So today is day 1 of this act. And employment law doesn't tend to move as quickly as it is now, but we're moving at lightning speed. Employers have newfound obligations. Employees have newfound rights, beginning at 12:01 a.m. this morning. So we're going to cover all those. There are many other legal issues that are impacted by COVID-19. I'm going to do a very brief laundry list of those at the end if we have time, but the focus on this presentation is squarely the FFCRA and the leave provisions of the FFCRA. You know, of course, you can't have an attorney without fine print. The fine print here is that everything's in flux right now. The law's in flux. The situation with the coronavirus is in flux. This law went into effect today, but the Department of Labor has not put out regulations about its enforcement yet. They have put out some guidance, but not any regulations. Things are moving lightning fast. So this is my best effort to give you an overview of this law. This information I'm giving is legal information. It's not specific legal advice, but if you want specific consultation, by all means, reach out to me. I'd be glad to talk with you and set up a time where we can talk. So as we said, this law goes into effect today. It's a temporary law that will be in effect until, it should be actually sunsets December 31st, excuse me, that's a typo, but it sunsets on December 31st of this year. And there's two parts of this law that deal with leave. The Emergency Sick Leave Act, which provides up to 2 weeks of paid emergency sick leave for employees with qualifying reasons, and the Emergency FMLA, Emergency Family Medical Leave Act, provides up to an additional 10 weeks of emergency FMLA leave for employees. So these two laws, they operate, the very big overview is these two laws operate together. And some employers are subject to neither of these laws. Some of them can waive parts of these laws, and some of them can't. Some employers can't waive any of the parts of these laws. So we're going to talk for a minute about, the coverage. And really the first analysis with coverage is for employers with over 500 employees or more. If you have 500 employees or more, you are not subject to either of these laws. So that's the first test. So there's not, employers with over 500 employees or more are not subject to either the 2 weeks of emergency sick leave for qualifying reasons, or the 10 weeks of emergency FMLA. Now, with employers with fewer than 500 employees, these laws generally apply, but there's parts of them that can be waived for small businesses and for employers that employ emergency responders and healthcare providers. There's also, even though there's parts of the laws that can be waived, that's not to say that they can all, the entire laws can be, all provisions can be waived. This is where it gets a little sticky. We'll get to that in a bit. So the whole idea behind the FFCRA is that covered employers must provide this leave to eligible employees unless they fit into an exception. In exchange, employers will receive tax credits that offset the cost of providing this leave. All right, the first thing we're going to look at is the first law is the Emergency Sick Leave Act, the ESLA. The ESLA provides 2 weeks of paid emergency sick leave to both full-time and part-time employees, for qualifying reasons. So we're talking about 2 weeks, or for full-time employees, 80 hours worth of compensation. The ESLA covers private employers with fewer than 50 employees. It covers state and local government employers with 1 or more employees, and it covers some federal agencies and some federal employees, and that gets a little confusing. So we're focusing primarily on the private employers aspect. Excuse me, let me make sure I said that clearly, because I'm part of my screen is blocked here. Covers private employers with fewer than 500 employees. Yeah. So all right. So the ESLA provides this 2 weeks of emergency sick leave for these covered reasons. Now this gets confusing because this list of covered reasons is from the Department of Labor's most recent guidance, which only came out a couple days ago. And the language is a bit broader than the language of the actual statute, of the actual law that Congress passed. But I'm going with here specifically what the Department of Labor says are qualifying reasons. First reason is employees who are unable to work or telework because of a quarantine or isolation order. The second reason is for employees who have been advised by a healthcare provider to self-quarantine. It doesn't necessarily mean that they have a diagnosis, but the healthcare providers told them to self-quarantine. The third reason is that the employee is experiencing symptoms and is seeking a medical diagnosis. Again, that's not with a diagnosis, a current diagnosis. They're seeking a diagnosis. Well, we want them to stay home and stay away from everyone else. So they are entitled to ESL. Fourth is that the employee is caring for an individual subject to an order described in 1 or 2. So we're talking about, so if you have if the employee is someone caring for someone subject to a quarantine or isolation order, or is caring for someone who has been advised to self-quarantine, then that can be that employee, even though they themselves are not subject to the quarantine, or they themselves have not been advised to self-quarantine, they still can use this emergency sick leave. Now, the next category is number 5 is an individual who's unable to work or telework because they're caring for a child whose school or place of care is closed for reasons related to COVID-19, or their child care provider is unavailable. Now, the actual statute refers to son or daughter of the employee. Now, but the Department of Labor is interpreting that to include, well, just as caring for a child is much broader. So that could be a point of dispute if push ever comes to shove on that issue. But I would probably advise employers to err on the side of granting emergency sick leave for anyone who is caring for a child for these reasons. And then the last one is, it's sort of a catch-all, experiencing any other substantially similar condition specified by the Secretary of HHS or the Secretaries of Labor and Treasury. And so we don't know what that is yet. There's not been any regulations or guidance on that at this time. I think it's important, before I go to the next slide, to note that it says unable to work or telework. So theoretically, if someone's able to work from home, then they may be able to continue to draw pay and not have to use ESL if they're working from home. So how much do people receive on this leave? Well, for reasons 1 through 3, which are focused on the employee being unable to work, the employee is paid 100% of their normal compensation, up to $511 daily. And since we're talking about 2 weeks or 80 hours or 10 work days, the total that they're paid would be, the max would be $5,110. So that's the max. So many employees are going to get paid 100%. for those reasons. Now, for reasons 4 through 6, the employee is paid 2/3 of their regular pay with a cap of $200 daily. And then we're talking for these, we're still talking about 2 weeks or 10 days, 10 work days, or 80 hours. So they get 2/3 of their pay up to $200 daily. So here's an example of how that would be calculated. So a full-time employee whose ordinary pay is $30 an hour and who works for 80 hours over 2 weeks would that's basically $240 a day. Well, they would ordinarily make $2,400 over 2 weeks. Well, if that employee was absent due to their own quarantine order or instruction to self-quarantine or symptoms or diagnosis, they wouldn't hit either the daily cap or the aggregate cap, and they would get paid their full wages for up to 10 days, 2 work weeks. So here's another example. A full-time employee whose ordinary pay is $30 an hour and who works 80 hours over 2 weeks, would ordinarily make $240 a day or $2,400 over those 2 weeks. If the same employee was absent to care for someone else, the lower hourly cap and total aggregate cap would apply and result in the employee's pay being limited to $200 a day for a total of $2,000 over those 2 weeks. So that's how that cap works. And I also want to mention that part-time employees are entitled to this as well. So if you have a part-time employee, they're entitled to their average pay that they would ordinarily, basically you would calculate their average pay for 2 weeks based on their past 6 months of work if they've been there for 6 months, or a shorter period of time if they've been there shorter than 6 months. And that's what they would receive during their ESL, emergency sick leave. Let me see here. All right. Employees cannot be required to find a replacement worker to fill their spot in order to take emergency paid sick leave. Emergency paid sick leave is on top of any other available leave that employees have accrued. If the employee has regular sick leave, the employee has PTO or vacation, they can't be forced to take those first. This is the first type of leave they can draw upon if they qualify. After they exhaust the emergency PSL, then if they still need to be absent, they can draw on those other types of leave. This is really important that HR folks understand this as they're rolling their policies out. Emergency PSL does not carry over from 1 year to the next. So at the end of the year, if an employee has not used emergency PSL, they don't get to take that into calendar year 2021. And they're not entitled to reimbursement for unused emergency PSL upon separation from employment. Now, emergency PSL does not carry over, we already said that. Now, leave approved and taken before April 1st does not count towards emergency PSL or emergency FMLA under the Act. So if you have employees who've been out of work due to coronavirus, either themselves or in their family or whatever, any circumstances it may be, you can't retroactively apply this leave to their absence prior to April 1st. And so they still have a right to emergency paid sick leave for if their absence is continuing to be required after April 1st or thereafter. All right, so that was the first part of the Family First Coronavirus Response Act. Now we're going to talk about the second part, which is this Emergency Family and Medical Leave Act, emergency FMLA. Now, as y'all are probably familiar, the FMLA does not apply to all employers. normally. It's based upon the size of the employer, how many employees they have. Well, this has a much broader application, emergency FMLA. It temporarily expands coverage of FMLA to all private employers with fewer than 500 employees, with the possibility that employers with fewer than 50 employees may be able to obtain a waiver from the Act's requirements. So the default is if you have fewer than 500 employees, then this applies. But as we'll discuss, there are steps you could take if you wish to try to waive that requirement. All right, so covered employers are required to provide up to 10 weeks of paid family leave for employees who are unable to work or telework due to the need to care for their minor child because the school or place of care has been closed or their child care provider is unavailable due to COVID-19. So the law is actually written in such a way that it provides 12 weeks of leave. The first 2 weeks are without pay, where they can apply any other leave they're eligible for, and then the next 10 are paid, as we'll see, at the 2/3 rate that we talked about earlier. And we'll talk about how it all. If you look at these two laws in conjunction, what it results in is, for covered employers and covered employees, 12 weeks of coverage in total. Like I said, the first 10 days, or in other words, the first 2 weeks of emergency FMLA are unpaid. The employees may choose to use any other types of leave they may have available, which I would typically be emergency PSL. After the first 10 days, the employer must pay 2/3 of the employee's regular rate of pay. And again, this is similar to the cap we talked about, or it's identical to the cap we talked about earlier, not to exceed $200 a day or an aggregate cap of $10,000. For part-time employees or those who work irregular schedules, the remaining time must be paid based on the average number of hours the employee worked prior to taking emergency FMLA. Like we said, to figure out what amount to pay a part-time employee, one looks at their average pay over the past 6 months, or if they've been there for fewer than 6 months, then it's necessary to look at the average amount of pay for the time that they've been there. To be eligible for emergency FMLA, the employee must have been employed with the employer for at least 30 calendar days before the date of the leave request. So emergency PSL applies regardless of how long an employee has been employed. That's the leave based on the first 2 weeks of leave applies regardless. Emergency FMLA only applies to employees who have been on the payroll for at least 30 calendar days prior to the leave request. So there's a difference there between the emergency PSL and the emergency FMLA. And we already covered this. The emergency FMLA counts towards FMLA leave limits. So if the employer is covered by FMLA, then we're talking about now regular FMLA, not emergency FMLA. If the employer is covered by regular FMLA because they are large enough that there's coverage, then the leave that an employee takes for emergency FMLA counts towards the 12 work weeks of leave that are protected during a 12-month period under FMLA. So if they've already taken some FMLA unrelated to COVID-19, or not emergency FMLA, let's say if they've been out of work on FMLA leave for 3 months, then they have fewer than 12 months left. They only have 9 months left of leave for emergency FMLA, if that makes any sense. So that 12 months, that 12 weeks, let me rephrase that. I think I botched that up. So regular FMLA covers 12 work weeks of leave. So if they've used 9 of those work weeks already for a reason unrelated to emergency FMLA, then what they have remaining is the 3 weeks that they haven't used during the 12-month period. So if an employee takes some but not all 12 work weeks, they may take the remaining portion of FMLA for a serious medical condition, as long as the total time taken does not exceed 12 work weeks in the 12-month period. So it gets a little bit complicated when we start trying to lay emergency FMLA onto the existing FMLA framework. So employees are entitled to paid sick leave regardless of how much leave they've taken under FMLA. So if the employee has exhausted FMLA for unrelated reasons to COVID-19, they still get those 2 weeks of paid sick leave. Now, under FMLA, employees are generally have their position protected while they're out on FMLA. Well, similarly, employers are generally required to restore employees to their previous positions after their emergency FMLA leave ends. Now, there are exceptions, particularly for employers with fewer than 25 employees, if the position no longer exists due to changes in the operating conditions of the employer caused by the public health emergency. So we're going to talk a little bit about some other provisions of these 2 laws. So the law provides for 100% reimbursement to employers who give employees this leave. So they are entitled to claim tax credits each quarter within the limits of the caps described above. They may also be eligible for a dollar-for-dollar offset against their payroll taxes. They may be eligible for the cost of providing group medical coverage during the employee's leave period. And there's provisions to help self-employed individuals as well. And it's really important, I think, that if the employers talk with their tax preparers, tax advisors to make sure this is all handled correctly and documented correctly. Now, this is where it gets interesting, the small business exception. One of the things, when I was preparing a blog post on this topic, I started researching it, and there's a lot of confusion about what small businesses can exempt out of. Different sources have indicated different things. This is my best understanding of what small businesses, employers with fewer than 50 employees, can exempt out of. So employers who have fewer than 50 employees can exempt out of those portions of both emergency PSL and emergency FMLA involving caring for children whose school or child care provider is closed. That is the only part of these laws that employers with fewer than 50 employees can exempt out of. But to seek that exception, to seek that waiver, the employer must be able to show that the leave requirements would jeopardize the viability of the business as a going concern. So just to illustrate this, this is our list of qualified reasons for taking emergency sick leave. If you look at number 5, that is the only qualifying reason that allows under which a small business can exempt having to provide leave. So if an employer has fewer than 50 employees, they can exempt out of the obligation to pay the employee to care for their child whose school or place of care is closed for reasons related to COVID-19. All the other reasons they're still bound to provide emergency sick leave for all those other reasons. Just again, this small, to make it absolutely clear, small businesses cannot waive these other reasons. See, they can waive that, they cannot waive those. Now, the Department of Labor has put out criteria for seeking the small business exception. These criteria are basically focused on the business, showing the businesses how the business's finances would be impacted by providing this, or how their workforce would be impacted. So we have there's 3 different categories, 3 different ways to seek exemption from this obligation. They can show that result in the small business's expenses and financial obligations exceeding available business revenues and cause the small business to cease operating at a minimal capacity. They can show, you can exempt out of it by showing that it would entail a substantial risk to the financial health or operating capabilities of the small business, or you can show that there are not sufficient workers who are able, willing, and qualified to perform the labor or services provided by that employee or employees requesting paid sick leave or emergency family and medical leave based on that reason. So how do you seek a waiver? Well, the statute talks about applying to the Secretary of Labor for the waiver, or that the Secretary of Labor would promulgate regulations. Well, the Secretary of Labor has not promulgated regulations yet on this process, but they have put out some guidance. And this is what the Department of Labor says. To elect the small business exemption, you should document why your business with fewer than 50 employees meets the criteria set forth by the department, which will be addressed in more detail in forthcoming regulations. You should not send any materials to the Department of Labor when seeking a small business exemption for paid sick leave and expanded family and medical leave. So what I take this to mean is that small businesses seeking this exemption need, and if we go back to the guidance, this is an authorized officer of the business to document, and I would recommend that small businesses document this in a memo from an authorized officer, the president of the business or a CFO or someone at the owner, saying we are exempting out of the requirement based on one of these 3 reasons, and then explain why the small business is eligible for this exemption. It has to be tied to one of these reasons. And I wouldn't send that in anywhere. I would just keep that in the file should the issue arise, and I would keep an eye on Department of Labor regulations, the Department of Labor website, just for in case they decide to put out a form or a process to formalize this process. All right. There's another exemption, the first responder exception. So healthcare providers and emergency responders, employers who employ them can exempt out of providing both types of leave. Employers may decline to provide both PSL and emergency FMLA to these individuals. And the Department of Labor defines healthcare provider and emergency responder very, very broadly. It's much broader than one would think. So, for example, if you look at the Department of Labor's guidance, someone working in a factory to make a vaccine for COVID-19 can be exempted out of this type of leave, either type of leave. So even though that person may not really directly be a healthcare provider, they could be a janitor at the factory, they would still, under Department of Labor guidance, be viewed as potentially exempt from the right to leave under the paid sick leave and emergency FMLA. Other people that are covered, things like 911 dispatchers or public works employees can be covered. So it's very important to look at the answers to questions 56 and 57 if you think that you have employees who may be covered, may be exempted from this particular type of leave. Now we're going to talk briefly about notice to employees about under the law. As of today, there should be a poster where employers have all their other labor law posters. There should be a poster about this leave. This is a free poster that's available at Department of Labor's website. It's also, if you go to our firm website, you should be able to find links there. It must be posted in the workplace conspicuously where employees will see it. I would recommend that notice should be sent to employees who are teleworking or working off-site with this poster or a link to it. And let's talk for a moment about employee protections. So employers who wrongly deny leave will be treated as failing to pay minimum wage pursuant to FLSA. So if an employer does not provide paid sick leave, and they should have, then it's also a violation of the Fair Labor Standards Act. The employers who retaliate against employees who pursue their rights under this act are treated as having retaliated against employees for raising their rights under the FLSA. And if you look at the Fair Labor Standards Act, there's potential liabilities for administrative fines, civil damages, like attorney's fees for the employee if they have to file suit, and even criminal penalties in some cases. So it's important to get this right. Now we're going to talk about the 30-day non-enforcement period. So the Department of Labor understands that this is a dramatic change to the law for many, many employers and employees. And so they have offered that they've indicated they will not pursue enforcement actions against employers for 30 days after enactment. But employers must act reasonably and in good faith to comply with FFCRA to receive the benefit of this pause. So what that means is, as I read it, the Department of Labor is saying we're not going to try to catch anybody in a technicality during this 30 days because we understand people are learning about this law and are adjusting. But we will only give people the benefit of this, only give employers the benefit of this if they are acting reasonably and in good faith. So I would advise employers to act reasonably. Don't require onerous paperwork or reporting requirements. Be flexible, and employees should be flexible. Everyone needs to be flexible during this difficult time. Employers need to develop a way to track this leave. They need to, if they haven't already, immediately develop and amend policies to document the process to notify, where employees can notify the employer of the need for this leave, how it's to be tracked. People need to be treated equitably. These policies need to be enforced equally across the board to anybody that's eligible. I really, really recommend that employers and employees that might be affected look at the Department of Labor's website frequently for updates. And I have a link at the end of this presentation. Well, actually, I have a link right here. So here are a couple of resources. This first is the blog post that I put together about the Families First Coronavirus Response Act. It actually has all the citations to the act that I was referring to in this presentation, and links to those parts of the act. Also, like I said, the Department of Labor's resource, COVID-19 in the American Workplace, is extremely useful. It has details about, guidance for employers, guidance for employees, and in particular, a question and answer resource it's got over 50 questions and answers that cover many, many details and questions you may have. Okay, so then briefly, I'm going to talk about issues we're not really talking about, but that are really, really important. So this is not the direct subject matter of the presentation, but I want to flag these issues for you because they are very important, and this is all probably worth other webinars or other consultations or research, because this stuff is happening fast, and my colleagues and I are seeing these issues pop up like crazy. First is in South Carolina, we have a law that protects employees who are subject to quarantine and isolation orders. It specifically says it's illegal to fire, demote, or otherwise discriminate against an employee complying with an isolation or quarantine order during a public health emergency. And it further says that nothing in this section prohibits an employer from requiring an employee to use annual or sick leave to comply with such an order. So, as Governor McMaster has ordered different industries and businesses closed, this is going to become an issue for any business that tries to that doesn't read those closures very closely, and it requires employees to work that may not be exempted by the governor's order. OSHA, the Occupational Safety and Health Act, is coming into play because we're getting calls from employees who are very, very anxious about being made to work in conditions they don't feel are safe. We're getting calls from employers who are trying to figure out how to continue their operations. So it's important to realize that COVID-19 is an OSHA issue. Employers are obligated, COVID-19 or not, to furnish each worker employment and a place of employment which are free from recognized hazards that are causing or likely to cause death or serious physical harm. So without getting into all the details, just know that OSHA, that COVID-19 is a workplace safety issue, and there are responsibilities to keep employees as safe as possible. Unemployment benefits is an issue that is coming into the forefront, and it comes into play potentially after an employee has exhausted emergency PSL or emergency FMLA, when they're no longer employed, or if the employer has been shut down by the economy or for whatever other reason related to COVID-19. Employees can potentially be eligible for unemployment benefits, and claims based on COVID-19 will not be charged against the employer. So I've had calls from employers trying to figure out how to help their employees, which I really respect those employers that are trying to figure out how to help their employees as best they can during this difficult time. Well, helping employees the employer can file the unemployment claim on the employee's behalf. That's extremely helpful, and it makes things go faster. Also, should be noted that the online work search requirements are waived during this time. So ordinarily, workers who are drawing unemployment have to look for work. Well, right now, for at least the time being, those claimants do not have to look for work. They're welcome to, but they don't have to, and they won't be disqualified if they don't. The deadlines for payment of unemployment taxes are extended, but the deadline for wage reports are not extended because the Department of Labor needs that information. And it's worth noting that employees who are still employed but on a reduced schedule may be eligible for partial benefits. So if they've had a dramatic decrease in their pay, or if they're on furlough but still on the payroll, just not getting paid, they can apply for unemployment benefits. But just be aware that paid leave, if somebody's out getting paid leave, that is wages, so that is likely to interfere with the ability to draw unemployment. Let's see here. The other thing, one thing I did want to note is that employers' payment of employees' health insurance might not be treated as wages. This came up in a webinar with unemployment attorneys from the unemployment office. Ashley Sweet, an excellent employment attorney in town, asked that question, and basically the due attorneys said that that they don't believe that would be treated as wages, so it wouldn't be offset from the benefits that the employee receives. Again, that's nothing exactly in writing, but it's worth noting. So if an employer is planning on trying to pay their employees health insurance premiums, that should work and not interfere with the employee's ability to draw unemployment. And then looking to the very near future, the CARE Act is going to increase the weekly benefit amount. It's going to expand eligibility to cover self-employed workers and possibly others. We don't know all the details, and we don't really know those details about unemployment and how it will be implemented in the state yet, because there's not information on the department's, on DU's website. My understanding is the department has to enter into an agreement with the Department of Labor detailing how they'll implement the provisions of the CARE Act. Then we'll get more information, which I would hope would be in the next week or so, if not sooner. All right, so there's some other laws that come into play. And just a quick laundry list and alphabet soup of these laws. We've got the Fair Labor Standards Act, which deals with wages and the handling of wages. Family Medical Leave Act, like we talked about, is still extremely important. Americans with Disabilities Act is being impacted by employees with pre-existing conditions and employees with disabilities and serious health problems. Title VII and how people are treated, whether they're treated equally based on their race, gender, origin, sex, those sorts of things is still important. Age Discrimination in Employment Act has got a role because of the significant impact that COVID-19 has on older people. I mean, it's documented to be severe for many people, but especially for older people. So that's a potential issue that may come up. That we're seeing a number of issues arising from employers not wanting their employees to talk about the conditions they're facing, and then threatening them with discharge if they go public with the conditions they're working in. Well, that's potentially a violation of the National Labor Relations Act. And then, as always, is the South Carolina Payment of Wages Act that requires payment of wages when due and payment of leave. And so these are all laws that continue in effect and that have a little different spin on them in the current environment that we're in. So we're here to help. Again, this is my contact information. Feel free to give me a call if this is something you feel like you need help with. We can schedule a consultation. Or give me an email, shoot me an email. It's an interesting, stressful, exciting, but mainly stressful time for everyone involved. And I appreciate you listening to this presentation. I'd be glad to take some questions now.
We're going to turn it over to Sully on some Q&A. Do want to say one thing before we get to the Q&A. Jack talked about the posters. We have actually posted that poster out to both of our websites, the employer website and the employee website. You can go out and grab the poster off of that. If you want to get on our email list, I send out an email when we update either site. It's under my email address, which I think was at the first of the presentation, nclark@clarkbenefits.com. And with that, I'll turn it over to Sully on some Q&A.
Hey, everybody. We have several questions, so I'm going to kind of go through them as I can. If you need to jump off, please, this webinar will be recorded and it will be distributed to all of you. And if you have specific questions, I am going to only go over the general ones. A couple of you asked very company-specific questions, so those I will follow up with you via email directly. But to get us started, the first question is, can the employer or the employee use the additional 80 hours of sick time the law allows in hourly increments to cover for an employee needing to leave work early due to child care needs?
All right, that is an excellent question. So the question is whether emergency paid sick leave can be used in increments.
Correct, in hourly increments.
In hourly increments. I don't see any restriction on that. I mean, if the employee needs that, and it falls within a qualifying reason, which it would, then I believe that is a valid use of emergency paid sick leave.
Okay, great. The next one, what if an employee asks for partial days off to assist child with schoolwork?
With that one, I would focus on the analysis on whether the need for the leave is to provide care. And I know that the schoolwork is difficult and it's hard. We have 2 kids at home and they're home, and it's a challenge. I mean, I guess the employer certainly could provide that leave, and it probably would qualify. I mean, you could make an argument that it's a qualifying reason, but I would frame it as a need to provide care for the children more so than on need to deliver schoolwork for the children, if that makes sense.
Yes, definitely. Okay, and please continue to ask these questions because we will get to them, whether or not it's during the webinar, we will follow up individually. The next one is, under 50 employees where the firm would be put in a financial distress to offer both of these, do they become exempt? And this was early on the presentation, so I'm not exactly sure which.
Okay, I don't mind talking about one. So if there's fewer than 50 employees, the employer is still subject to the 2 weeks of emergency paid sick leave requirement for all reasons except for an employee needing to provide care to a child whose school is closed. So there's no way to, in my understanding, in my reading, there's no way to exempt out of the requirement to provide those 2 weeks because someone's sick with COVID-19 or has symptoms or is under a quarantine order or has someone else in their household that they have to care for who's sick with COVID-19 or under a quarantine or isolation order. I think all employers under 500 employees have to provide that leave unless they are covered by the exception for healthcare workers and emergency responders.
Okay. Next, we have, what if you have an employee that was on FMLA for maternity leave prior to ESLA?
So that employee would have drawn down their 12 weeks that they're entitled to for a year for however long they were out on maternity leave, and they can't draw more than a total of 12 weeks, including the emergency FMLA. They can, however, if they qualify under that emergency paid sick leave, that's a different pot, basically, a different pot of leave. And even if they've used up all 12 weeks of their FMLA, they could still draw down the 2 weeks that are provided under emergency paid sick leave if they have a qualifying circumstance.
Okay, thank you. Let's see. Next one, is it safe to assume that a stay-at-home or shelter-in-place order falls under the definition of isolation order or quarantine for the ESLA? Or does the employee's isolation or quarantine have to be specifically related to a COVID medical issue?
That's a really good question, and I don't know. I'm going to take a pass on that until I can look at to see if the Department of Labor has guidance on what exactly counts as the quarantine or isolation order. But I'll try to find that out.
Okay, yeah, we will be in touch about that question. I'll connect you via email. Okay, for the waiver from the DOL of the acts of requirements, does this have to be filed to be exempt, or can we just document that we are claiming exemption?
Currently, you just document it because the Department of Labor specifically said we do not want this documentation. Do not send it to us. However, I most certainly would recommend documenting it because that could change. They could say tomorrow that, hey, okay, we now have a process, send it to this address. So yeah, I would certainly do a memo explaining why, a memo, according to the Department of Labor, it needs to be an authorized officer, whoever that might be, explaining why they believe they're exempt under one of those 3 criteria.
Okay, the next question kind of piggybacks on that. You mentioned provided it's documented correctly for tax credits. What's the best way to be documenting this?
For the tax credit?
Yes.
Well, the Department of Labor says in its guidance that it's important to document the employee's need for leave, but that requirement to document shouldn't be onerous. So I know it's kind of speaking out both sides of my mouth on that, but you would want to be able to show the IRS for this tax credit purpose that the employee was out for a valid reason, a valid qualifying reason. So for example, a school closure order, would be good documentation for why someone's out for that category involving school closures. That makes, I wouldn't require much more than that in terms of documentation, because it's pretty much self-explanatory. I would probably want, if I were an employer, I would want some sort of documentation ultimately about someone's diagnosis or that they, I don't know, I wouldn't be too onerous, because it's very hard. There's people getting medical care through telemedicine, so they're not going to necessarily get much documentation, but I would try to, as best I can, document, maybe a memo to the file saying this person called in, saying that they're having symptoms. I think that would be good documentation. So we do the best we can under these difficult circumstances. I would want to have something to show the IRS if I was an employer, if they came back and asked why I'm seeking this credit. But I wouldn't necessarily require the full documentation that somebody might be, might otherwise be required for FMLA or other types of leave, because the circumstances make it so hard to get that sort of documentation. I'm not sure doctors are even really doing doctor's notes at this point. They're in emergency mode, and they don't want to be having pieces of paper handed back and forth that could potentially cause infection. So I would hesitate to require any kind of onerous requirement for employees.
Sully, also on that, I will chime in on both the employer and the employee website. We've got a sample fillable document out there for leave purposes.
Oh, great.
And the employee or the employer could go out there and fill that out, save it as a PDF, and email to the employer, and it's out on both websites too. For just a very simple, it's a one pager, and for some employers, if you want, we've already customized that too to their names. If you want to do that, just contact us. But it's out on both websites.
That's excellent.
And these websites will be emailed to, if you join the webinar late, I will include those website resources on my follow-up email.
Very good.
Okay, the next question, and Jack, please feel free to interrupt me if you need to jump off. I know we're getting close to an hour. But the next question is, if employee calls out for a cough and states that they want to use the CARES Act and there are disclosed lung issues, 1, do they qualify for ESL since they stated a cough but no fever? And 2, can we furlough them so they'll get more income?
Could you repeat that one more time? I just want to make sure I'm not missing the...
Yes, okay. So if an employee calls out for a cough and states that they want to use the CARES Act and there are disclosed lung issues, 1, do they qualify for the ESL since they stated a cough but no fever? That's the first part. And then secondly, can they furlough them in order to get the employee more income?
That's a tough one, because having symptoms is a covered qualifying reason. I don't know, the act doesn't go into which symptoms or how many symptoms. I don't think, if it's more beneficial to the employee to be furloughed rather than take the leave under the ESL, then that might be an option for the employee and the employer to talk through, because compensation is going to be limited to the cap on the emergency sick leave. I don't know. Yeah, I'm not sure. Honestly, I don't know what, I mean, it's clearly a symptom, and if it were documented, I think that no one would really object. I can't imagine the IRS getting into the issue of whether or not this person's only got one symptom versus two symptoms or three symptoms. So the employer can certainly give the leave based on that symptom if they choose to. And I would probably advise employers to err on the side of approving rather than denying during these difficult times. And the other thing I would probably state that is if you wouldn't want the employee coming to work with that symptom because they might potentially infect other employees, then you probably should also qualify them for the emergency sick leave. I mean, it's one of those that those two concepts should run together. Because ultimately the goal of the emergency sick leave and then Family First Coronavirus Response Act is to help employees not have to come to work so they're not spreading this illness. So kind of read in conjunction with the purpose, it's important to be reasonable. Anyway, I don't know. I feel like I'm kind of dancing around that question a little bit. It's hard for me to fathom how it would be more beneficial for the employee to be furloughed, but I suppose that is an option that the employee and the employer can discuss.
Okay, thank you. Next, let me see. How is child defined? Is there a certain age where it drops off?
So child is defined as, well, the act itself says son or daughter of the employee. The Department of Labor, I'm just getting out the language here right now. The Department of, okay, so the act itself says it makes no reference to whether the employee is a minor or not. It simply says the employee is caring for a son or daughter of such employee if the school or place of care of the son or daughter has been closed or the child care provider of such son or daughter is unavailable due to COVID-19 precautions. So there's no reference to age there. Now, the Department of Labor has changed it to caring for a child whose school or place of care is closed. And so it doesn't even refer to it being the biological child or adopted child or anything like that. It could, under FMLA analysis, in loco parentis, a child who's an employee who just as a practical matter is, for all intents and purposes, the parent of the child, even if they're not the biological parent, can still be treated as covered. So there's no reference to age, but I would follow the guidance of the FMLA, and if it's someone who is a child, including in loco parentis, that requires care, if it's somebody, perhaps a child with special needs who may be 18 or above the age of 18, I think in that instance, they may still be covered under the Emergency Paid Sick Leave Act and the Emergency FMLA.
Okay, great, thank you. Next we I have commissioned employee. One is unable to come into work because he has COVID. He is home quarantining, but continuing to receive commission paychecks each week, even though he is not logging any hours because he is getting paid as we deliver the goods he has already previously sold. If he receives commission checks while out on leave, is he still eligible for sick leave benefits from these acts?
I have not considered commission-based compensation and how that would be affected. I honestly, I hesitate to say, because I believe that's the kind of issue that requires some additional research before I could really, I don't want to guess off the cuff on that one. I'm sorry. But I hope
that's okay. We'll follow up with him via email and make sure we get the question answered. All right. I'm sorry, I'm trying to kind of sort through these to make sure we haven't already covered them. Does FFRCA apply to domestic household employees?
I believe that I believe it does. I mean, I think at least the part of it that involves the paid sick leave part of it for all the reasons other than needing to stay home with a child. And there's no exemption from domestic household and before domestic household employees from that. I mean, that's my reading of it. Typically, those sorts of laws would typically, if they intended to exempt domestic household employees, that would be stated in the statute. But there's nothing there about that I've seen.
Okay. If we are under 50 employees and normally do not have to implement FMLA, do we have to implement EFMLA?
If under 50 employees?
Yes.
If there's under 50 employees, then they can seek the small business, they can go through the process to seek the small business exception from the emergency FMLA, which is, showing the hardship based on the reasons described.
Okay. Does an employee need to be paid under emergency PSL if they have spent an extended period of time in the hospital unrelated to COVID-19?
The emergency PSL only applies for the qualifying reasons that we talked about. So if the time in the hospital was not for treatment for COVID-19, then this leave does not apply to any other hospitalization. And also, as a reminder, it only applies going forward also. So if somebody's been out of work, if they're out of work yesterday, even if it was a qualifying reason, they don't get emergency PSL for that because the law wasn't into effect until today.
Okay. Can we require documentation for child care leave? And if so, what is valid documentation?
The Department of Labor has stated that just a general order that schools are closed is appropriate documentation for the tax credit purpose. So that's the only documentation I know of that's really required. I can't imagine, it's hard for me to figure out what other documentation would be necessary. I mean, perhaps if it's, I could imagine that it might be a certification from the employer that this person is their child, or that they have child care responsibilities because this employee, because the schools are closed. I mean, that might be good to have. But I mean, if it's not disputed that they have minor children who are in school, if it's not disputed that they have minor children, then them saying it's necessary for childcare purposes because schools are closed, I mean, that seems to me to be fairly self-documenting, I guess.
Right.
And I don't know. I wonder, Norman, do you have some sort of paperwork for an employee to certify they have this need? Just out of curiosity.
Both of the notices. There are actually two notices, one for the ESL, one for the FMLA out there. So they're both out there. As I've talked through with some clients, we've talked about just getting a notice from the paper or the school that schools are closed, or emails from the school for schoolwork that they're sending out to parents, and for that. Most employers, as you were saying, Jack, are being pretty lenient about this. We know that the schools and the daycares are closed. We see it every day. So from a documentation standpoint of that, the actual notice on the websites actually just give the qualifying reason for that. And as we were talking through with some others, a lot of people are going through telehealth. You can't even get tested really on some places unless you go through telehealth. So it's a pretty lenient thing. And again, I go back to what you said. I wanted to comment, but going back, you don't want anybody in your office if you're still working in an office or a factory, anybody else exhibiting any symptoms. And I think the DOL and all the governing bodies are going to be very lenient on this, because if you get it in your factory or you get it in your facility, you're probably looking at closing that down for a time period to get it cleaned and get people back in. So I would just err on the side of caution on all of this too, and use common sense. And I think you went back over it, as there's going to be 30 days of lax enforcement here, and you're doing best case scenarios here, I think too. So again, prudent things and that. Jack, how are you looking on time?
I think I'm about, I might need to break away here in a little bit, but I can maybe handle one or two more questions. And we'll...
Okay, so let's do one or two more questions, and then I'll close it down after that, so if you don't mind.
Okay. If an employee was around a friend who had symptoms that seemed familiar to COVID, but the friend was never tested, he thought it best to stay away from work just in case that friend was positive. Does this employee qualify for sick leave?
The terms of the emergency, the qualified reasons, I mean, we just kind of have to go back to the qualifying reasons, and I'm going back to the Department of Labor statement of those things. I think that the question is going to be, has a healthcare provider advised this person to self-quarantine? So if the healthcare provider for the friend who developed COVID-19 said, here, who have you been in contact with? And said, oh, well, all those people need to self-quarantine, then I would say circumstance 2, qualifying reason 2 might apply in that circumstance. If the employee just is on her own saying, hey, I need to be away from everyone, then I mean that gets to be a little bit far from the actual literal reading of the qualifying reasons. I mean, I certainly, I can see why she would want to do that, and I can see why the employer might want her to self isolate as well. So, but I would try to phrase it as, has the person who is actually diagnosed been told who they've been in contact with should self-isolate? And if the answer is yes, and I think you're squarely in that second qualifying reason.
Okay. Thank you so much. There are still several questions to be answered, but I will do my best to reach out to everyone individually to make sure that we get these questions answered, and connect you with Jack.
Jack, I got one.
Go ahead, Norm.
Jack, I got one question for you, and then I'll go ahead and close us out.
Okay.
On the tax credits, as an employer who's paying an employee for ESL and emergency FMLA, has there been any guidance yet on when we can take the credits against our tax payments? Can we go ahead and start doing that on our next payment if we're paying money out? Because we do have a lot of employers who cash flow right now is probably not as good as in normal times, and they're worried about getting too far ahead and getting reimbursed here. So do you know anything on that?
As what I know about that, I'm not a tax attorney, so it makes me a little anxious to speak too much on that. But I know that tax credits can be taken quarterly, and I know that there's also a provision that allows an offset for payroll taxes. So what that looks like and how it works, I don't quite know. But it might be good to go ahead and start talking with for businesses that are affected to talk with their tax advisors, because I would imagine that they're probably getting that guidance from the IRS now about how that works.
Well, I appreciate it. I'll reach out. We're working on the CARE Act with some with some accountants too. So I'll reach out to them on that, and we'll push that out as soon as we get some information on that. I do want to thank Jack for taking the time today. Jack, it's been very informative. I've learned a lot. You did a great job. Right now, as we all know, information is key. We're all consuming as much as we can because, as Jack stated, and I said earlier, things are moving at lightning speed. And as we get information, again, we'll post to our website. We've got people working all day, reading, reviewing, and putting out. Jack's put up his email, and Sully's going to put it out there, and we'll post the webinar too. So I do want to thank everyone for their time today. I do want to say that I think Jack's made himself available. Myself and all the staff at Clark & Company are available to answer a rundown. We actually have access to a team of HR professionals that if we got a question that we can't answer right off the bat, we'll send it up to them. It's taken about 2 or 3 days to get answers back due to the volume, but we can get you some answers back how it relates to the interpretation that we've got at the moment. As we know, it does always change. But again, I want to thank everyone for their time today. We're here to answer questions. Jack, thank you, and everyone over at Burnette Shutt McDaniel for all the preparation you've put into this. And hopefully it was informative to everyone, and we'll keep everyone posted, hopefully for a webinar coming next week. So again, thank you for your time. And with that, we'll conclude the webinar today.
All right, thank you.